Hello and welcome to this podcast Bites by IndiaLaw LLP. I am Ayush Shukla and today we discuss an important judgment of the Bombay High Court in Nayara Energy Limited versus Mahendra Sales Services. This judgment is significant for businesses, franchise operators, dealership, arrangements, and parties involved in commercial arbitration. It clarifies a key principle. While arbitral tribunals have a wide power to decide contractual dispute, they cannot rewrite commercial contracts or grant relief that are contrary to law. The dispute arose from a franchise agreement relating to operation of a retail fuel outlet. The original franchise agreement was entered for running a petrol pump dealership. Subsequently, the respondent claimed to have stepped into the shoes of the earlier franchise and asserted that it had invested in land, machineries and equipments for operating of the outlet. The company later terminated the franchise agreement on the ground that the required minimum sale targets were not achieved. This termination became the central issue in the arbitration. The arbitral tribunal held that a contractual relationship existed between the company and the respondent. It was further held that the termination was illegal because the respondent had not been given prior notice or an opportunity of hearing before termination. On this basis, the tribunal set aside the termination, restored the dealership, and awarded compensation of Rs 4 lakh with interest 6% per annum towards machineries and equipments. The company challenged the arbitral award before the Bombay High Court under Section 34 of the Arbitration and Conciliation Act 1996. The High Court examined the matter from three key legal angles. First, the issue was whether an arbitrator can invalidate the termination of a private commercial contract only because no prior hearing was given. The court held that in commercial contract, the right of obligation of the parties must flow from the contract itself. If the agreement does not require a prior show cause notice of hearing before termination, such requirements cannot be imposed by the arbitrator on the basis of the general principles of fairness or natural justice. The finding is important because it draws a clear distinction between public law principles and private commercial contracts. Principles of natural justice may apply in administrative or statutory decision making. However, in private commercial arrangements, the arbitral tribunals must decide the dispute according to the terms of contract and applicable law. The second issue was whether the arbitral tribunal could restore the dealership after holding the termination to be illegal. The High Court held that the dealership arrangement was a determinable contract. Under the principles of Specific Relief Act, a contract which is by nature determinable cannot ordinarily be enforced. Therefore, even if the termination was assumed to be wrongful, the appropriate remedy would generally be damage and not restoration of the contract. The principle is highly relevant for dealership, franchise, distribution, supply, and similar commercial contracts. Courts and tribunals generally do not compel parties to continue a private business relation where the contract itself is terminable. In such cases, the aggrieved party must establish breach and prove damages. The third issue was whether the compensation could be awarded without proper pleadings and evidences. The court found out the award of Rs 4 lakh towards the machinery and equipment was not supported by sufficient pleadings or evidence. The burden was on the claimant to prove alleged investments, valuation of machinery, depreciation, and actual loss suffered. The arbitrator could not award compensation merely because the opposite party had not provided detailed contrary pleadings. Therefore, awarding compensation without proper evidence and contrary to the contractual framework amounted to patent illegality. Accordingly, the Bombay High Court held that the arbitral award was contrary to the terms of contract and the substantive law. The court therefore set aside the award in its entirety. The key takeaway from this judgment is that arbitration is not a forum for rewriting commercial contracts. An arbitrator must operate within the boundaries of the agreement between the parties. The termination rights, performance, obligation, consequence of breach, remedies must be determined strictly by the contract and the applicable law. For businesses, this judgment reinforces the importance of precise contract drafting. Termination clauses should clearly specify the grounds of termination, whether the prior notice is required, the procedure to be followed, and the remedies available in the case of breach. For parties making claim in arbitration, the judgment is also a reminder that the damages must be proved through proper pleadings and evidence. Claims relating to investment, depreciation, loss of business, and compensation must be supported by documents, valuation materials, correspondence, and proof of actual loss. From a Section 34 perspective, this judgment also shows that while courts do not sit in appeal over arbitral awards, they can interfere where an award ignores the contract, grants impermissible relief, or suffers from patent illegality. To conclude, the Bombay High Court decision in Nayara Energy Limited versus Mahendra Sales Services strengthens contractual certainty in commercial arbitration. It confirms that the arbitral tribunals must respect the bargain between the parties and cannot grant relief that the law does not permit. Stay tuned for more podcast bites by IndiaLaw LLP, where we discuss key legal developments and their practical impact on businesses and commercial decision makers. Thank you.